Good day, Crime Talk aficionados. We have a great show for you today. First, let's get to it. P. Diddy was arrested last night, and, it doesn't look good for him. We'll see if he gets out of custody. Ashley Benfield gets her request granted, just as I had predicted. Donna Adelson trial is paused and probably going to need to be delayed. A case about self-defense or murder. A jury will decide. We have a This Day in History story and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment down below, and hit that little bell for notifications. And remember, you can check us out anytime on any of your favorite podcasting apps. Now, it is Tuesday, September 17th. So what does that mean? Well, it's Tuesday, which means we have our Tuesday night live program this evening. So join us 6 p.m. Mountain Time. Last week it had to be canceled due to things that come up in the practice of law. And as of right now, nothing has come up that'll change that. So join us 6 p.m. Mountain Time. We have a lot to talk about. Obviously, we can talk about P. Diddy. We're going to talk about Kohberger. And we're also going to be talking about the Linda Stanley matter. You know, the prosecutor who's getting disbarred for her handling of the Barry Morphew matter. Yeah, we've got that order as well. So please join us 6 p.m. Mountain Time tonight. And before we get to the docket today, let's pay some bills. Ladies and gentlemen, go to this link, crimetalksearch.com. When you do that, you're going to be rerouted to a background subscription service. And when you sign up, you can do as many background searches on anybody as you would like. And you're going to get information as to, I don't know, are they married? Are they divorced? Have they filed for bankruptcy? Do they have a criminal record? Do they have to register on one of those public lists, if you know what I mean? That's right. Go to crimetalksearch.com, find out. The report is literally prepared while you wait and then emailed to you. And here's the beautiful thing. You can keep it and save it for as much time as you want. And guess what? When you have that subscription, like I said, you can look for anybody here in the United States. Cancel any time you desire. CrimeTalkSearch.com. You're going to be happy you did. Check out everybody that's coming into your life. All right, let's go ahead and open the record for Tuesday, September 17th, 2024. And yes, I'm sure everybody heard about it late last night. Sean P. Diddy Combs, a.k.a. Puff Daddy, a.k.a. P. Diddy, a.k.a. Diddy, a.k.a. PD, and a.k.a. Love. Well, he got arrested, and the indictment has been unsealed. And frankly, we'll give old P. Diddy, Sean Combs, the presumption of innocence, but it doesn't sound good for him. All right, so what do we know? First, the unsealed indictment against Mr. Combs reveals some new allegations of how he sexually and physically abused women and men. And the rapper has been charged with 3 crimes: racketeering, sex trafficking, and transportation to engage in prostitution. Now, the indictment, like I said, which was unsealed this morning, gave us a little insight into his alleged behavior, but didn't name the many people accused of helping him perpetrate the crimes alleged. Now, among the most sordid revelations was that more than 1,000 bottles of baby oil and lube were seized from his home. I'm sure his attorney will say, hey, he shops at Costco, he buys in bulk. You never know when you're going to need 1,000 bottles of baby oil. Anyway, Mr. Combs was also accused of making women have sex with male prostitutes until they were so exhausted that they had to get an IV drip to kind of bring them back to life. Now, according to Mr. Combs' attorney, he was arrested overnight in New York City after traveling voluntarily to New York. And Mr. Combs, formerly known as Puff Daddy, is expected to appear in court about 2:30 p.m. Eastern Time. This won't be televised. And the question of the day will be, it'll be an arraignment, a detention hearing, and a discovery conference. The arraignment is he'll enter a plea of not guilty, and then the matter will be sent to a district court judge, usually appearing before a magistrate for these matters. Then they'll have a detention hearing. Now, we'll talk about this in just a second, but there's kind of a issue. Is he a danger to the community and a flight risk? According to this indictment, which we'll go over in much greater detail, ladies and gentlemen, I assure you, if this was anyone other than P. Diddy, it'd be a no-brainer. They would remain in custody pending trial. We'll see if the package that P. Diddy satisfies the court's concerns that he's a danger to the community and a flight risk. So, like I said, we'll take a look at that much closer here in just a second. Now, as you may recall, Mr. Combs has been sued by several people who say that he subjected them to physical and sexual abuse. He's obviously denied these allegations. He's settled a couple of these allegations, but his attorneys are saying this is an unjust prosecution. We'll see. I hate when attorneys go to the extreme like that. Listen, your client's been charged. You're going to wait and see all the evidence. And you're not going to make any public comments. That's normally what you do. That's what you should do. That's what I would do. Anyway, now during the search of Mr. Combs' home in Miami and Los Angeles this year, police seized narcotics and, like I said, 1,000 bottles of baby oil, lubricant, and also several firearms. Now, the federal authorities say that Mr. Combs used a criminal enterprise to engage in a sex trafficking, kidnapping, arson, bribery, and other crimes ring. Kind of the most disturbing is that he would have freak-offs where they were elaborately produced sex performances that Mr. Combs personally arranged, directed, and pleasured himself to, and often recorded them, according to the indictment. What do you bet some of those are in the computers that they seized from Mr. P. Diddy's house? Anyway, it's alleged that Mr. Combs would allegedly make women have sex with male prostitutes by drugging them, and these freak-offs would apparently go oftentimes for days. And the indictment alleges that after the freak-offs, Combs and the victims typically received IV fluids to recover from the physical exertion and drug use. And the prosecutors also claim that in December of 2011, Diddy co-conspired to set fire to someone's car by slicing open the car's convertible top and dropping a Molotov cocktail inside the interior of the car. And then apparently Mr. Sean Combs bragged about destroying that person's car. Now, like I said, he's scheduled to be in court at 2:30 p.m. today, which is obviously, we're filming this, so we don't know what's going to take place. But Mr. P. Diddy, Sean Combs, does not want to remain in custody. But the United States Attorney doesn't want to let him out on a bond. Now, the U.S. Attorney says his office believes that Mr. Combs is a flight risk and also a danger to society, and he resorts to violence against multiple people, and it's, frankly, it's plausible that he would do it again. Prosecutors also point to the fact that he is facing a mandatory minimum sentence of 15 years to life in federal prison. Quite a motivation to leave the country, you would think. Anyway, Mr. Combs, quite the deal maker, says, hey, hold on. I'm going to propose a $50 million package to secure my release, and I'll show you that I'm going to come back. So P. Diddy's, or Mr. Combs' legal team has filed an offer with the federal court saying that we're going to put up two of his residences, one worth $48 million that he just recently paid off, because he frankly anticipated this. And if he was a flight risk, wouldn't he have left already? And the other $2 million would be his mother's home that would be used as collateral. He's also agreeing to have his travel limited to just Florida, New York, and New Jersey. And, that's all he needs to do. And he's also willing to wear a GPS monitor so the feds can track his whereabouts at any time. And apparently, like I said, he's been prepping for this. That's why he paid off his home. There was an $18 million loan that was still remaining. And he's also in the process of selling his jet. It's currently parked in L.A., but he is willing to not fly on it just so he can show goodwill. What can you do, ladies and gentlemen? Now, I think it's worth going over the indictment itself. Count one, the racketeering conspiracy. It alleges, and I'm going to leave out some of the surplusages just to avoid repeating all of Sean Combs' aliases over and over again. But it alleges that for decades, Sean Combs abused, threatened, and coerced women and others around him to fulfill his sexual desires, protect his reputation, and conceal his conduct. To do so, Combs relied on employees, resources, and influence of the multi-facet business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other crimes, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. They go on to say Sean Combs operated his business, headquartered at various times in Manhattan and Los Angeles, under a variety of U.S.-based corporate entities, including Bad Boy Entertainment, Combs Enterprises, and Combs Global, collectively the Combs businesses. Corporate entities in the Combs business included, among other things, record labels, a recording studio, an apparel line, an alcohol spirits business, a marketing agency, and a television network and media company. At all times relevant to this indictment, Sean Combs engaged in a persistent, pervasive pattern of abuse towards women and other individuals. The abuse at times was verbal, emotional, physical, and sexual. And as part of this pattern of abuse, Combs manipulated women to participate in highly orchestrated performances of sexual activity with male commercial sex workers. At times, Combs and others acting at the directions made arrangement for women and commercial sex workers to fly to Combs' location. Combs ensured participation from the women by, among other things, obtaining and distributing narcotics to them, controlling their careers, leveraging his financial support, and threatening to cut off the same, and using intimidation and violence. Physical abuse by Combs was recurrent and widely known. On numerous occasions from at least in or about 2009 and continuing for years, Combs assaulted women by, among other things, striking, punching, dragging, throwing objects at, and kicking them. The assaults were at times witnessed by others, including one instance at an LA hotel on about March 2016, which was captured on video and later publicly reported, where Combs kicked, dragged, and threw a vase at a woman as she was attempting to leave. When a member of the hotel security staff intervened, Combs attempted to bribe the staff member to ensure his silence. Combs' violence was also not limited to these women. It extended to his employees, witnesses to his abuse, and others. The Combs Enterprise, from at least 2008 and through the date of the filing of this indictment, Sean Combs, the defendant, and others known and unknown were members and associates of a criminal organization, the Combs Enterprise, or the Enterprise, and members and associates of the Combs Enterprise engaged in and attempted to engage in, among other activities, sex trafficking, forced labor, interstate transportation for purposes of prostitution, coercion, and enticement to engage in prostitution, narcotics offenses, kidnapping, arson, bribery, and obstruction of justice. The Combs Enterprise constituted an ongoing organization whose members functioned as a continuing unit for common purpose of achieving the objectives of the Combs Enterprise. The Combs Enterprise was engaged in and activities affected interstate and foreign commerce, and the enterprise operated in the Southern District of New York and elsewhere. At all times relevant to this indictment, Sean Combs was the leader of the Combs Enterprise, and Sean Combs participated in unlawful and other activities related to the conduct of the Combs Enterprise affair. These individuals included certain Combs business employees, such as the Combs security staff, household staff, personal assistants, and high-ranking supervisors, as well as other close associates of Combs. What was the purpose of the alleged enterprise, according to the indictment? The purpose of the enterprise included operating a global business in the media, entertainment, and lifestyle industries, including, among other things, record labels, a record studio, an apparel line, an alcohol spirit business, a marketing agency, and a television network and media company. Preserving, protecting, promoting, and enhancing the power and reputation of Sean Combs, the defendant, as a musician, entrepreneur, and figure in the entertainment industry, enriching members and associates of the enterprise, including its leader, Combs, and in particular, those who demonstrated loyalty to Combs and willingness to conceal his crimes, preserving, protecting, promoting, and enhancing the power of the Combs Enterprise, including the power of its leader, Combs, through violence, use of firearms, threats of violence, coercion, and verbal, emotional, physical, and sexual abuse. Fulfilling the personal desires of Combs, particularly those related to Combs' sexual gratification, including through the exploitation of women and the use of commercial sex workers. Enabling Combs and others, members and associates of the Combs Enterprise, to engage in unlawful acts of violence, including sexual violence, sex trafficking, forced labor, interstate transportation for purposes of prostitution, coercion, and enticement to engage in prostitution, narcotic distribution, and other crimes, and concealing the commission of such acts. Securing absolute loyalty from members of the Combs enterprise. Protecting the Combs enterprise and its members and associates. The means and methods of the enterprise. The Combs enterprise wielded the power and prestige of Combs' role as the Combs business to intimidate, threaten, and lure female victims into Combs' orbit, often under the pretense of a romantic relationship. Combs then used force, threat of force, and coercion to cause victims to engage in extended sex acts with male commercial sex workers that Combs referred to as other things as freak-offs. Freak-offs were elaborately produced sex performances that Combs arranged, directed, masturbated during, and often electronically recorded. In arranging the freak-offs, Combs, with the assistance of members and associates of the Combs enterprise, transported and caused to be transported commercial sex workers across state lines and internationally. Freak-offs occurred regularly, sometimes lasting multiple days, and often involved multiple commercial sex workers. And during freak-offs, Combs distributed a variety of controlled substances to victims, in part to keep the victims obedient and compliant. Sometimes unbeknownst to victims, Combs kept videos he filmed of victims engaging in sex acts with commercial sex workers. After freak-offs, Combs and his victims typically received IV fluids to recover from the physical exertion and drug use. Members and associates of the Combs enterprise, including high-ranking supervisors, security staff, household staff, personal assistants, and other Combs business employees, facilitated the freak-offs by, among other things, booking hotel rooms for the freak-offs, stocking the hotel rooms in advance with the required freak-off supplies, including controlled substances, baby oil, lubricant, extra linens, and lighting, cleaning the hotel rooms after the freak-offs to try to mitigate wound damage, arrange for travel for victims, commercial sex workers, and Combs to and from the freak-offs, resupplying Combs with requested supplies, delivering large sums of cash to Combs to pay the commercial sex workers, and scheduling the delivery of IV fluids. And then in or about March of 2024, during searches of Combs' residence in Miami, Florida, and Los Angeles, California, law enforcement seized various freak-off supplies, including narcotics and more than 1,000 bottles of baby oil and lubricants. Combs subjected victims to physical, emotional, and verbal abuse to cause the victims to engage in freak-offs, and Combs maintained control over his victims through, among other things, physical violence, promises of career opportunities, granting and threatening to withhold financial support, and by other coercive means, including the tracking their whereabouts, dictating the victims' appearances, monitoring their medical records, controlling their housing, and supplying them with controlled substances. During and separate from freak-offs, Combs, among other things, hit, kicked, threw objects at, and dragged victims at times by their hair. The assaults often resulted in injuries that took days or weeks to heal. Combs also threatened victims' careers and livelihoods, including if they resisted participating in freak-offs. Victims believe they could not refuse Combs' demands without risking their financial or job security or without repercussions in the form of physical or emotional abuse. Combs also used the sensitive, embarrassing, and incriminating recordings that he made during freak-offs as collateral to ensure the continued obedience and silence of the victims. Now, members and associates of the Combs enterprise included Combs. Security personnel at times carried firearms. On more than one occasion, Combs himself carried and brandished firearms to intimidate, threaten others, including victims of and witnesses to its abuse. In or about March of 2024, during searches of Combs' residence in Miami, Florida, and Los Angeles, law enforcement seized firearms and ammunition, including 3 AR-15s with defaced serial numbers, as well as drum magazines. Members and associates of the Combs enterprise enabled Combs' control over the victims by following his direction regarding financial payments to victims, advancing or suppressing the victims' career opportunities, and acquiring the controlled substances Combs used to keep the victims compliant. Members and associates of the Combs enterprise at times witnessed Combs' violence toward the victims or the victims' injuries caused by Combs without intervening. Instead, members and associates of the Combs enterprise helped conceal the violence and abuse by, among other things, assisting Combs in monitoring and preventing victims from leaving locations such as hotels or Combs' residence. These occasions included instances in which a victim was required to remain in hiding, sometimes for several days at a time, to recover from injuries Combs inflicted without being publicly observed. Members and associates of the Combs enterprise also assisted Combs locating and contacting victims who attempted to flee his abuse. When employees, witnesses to his abuse, and others threatened Combs' authority or reputation, Combs and members and associates of the enterprise engaged in acts of violence, threat of financial, reputational harm, and verbal abuse. These acts of violence including kidnapping and arson. In addition, on multiple occasions, Combs threw both objects and people, as well as hit, dragged, choked, and shoved others. When Combs' authority or reputation was threatened by the possibility of negative publicity or law enforcement actions against him, including in or about late of 2023, following the public allegations of Combs' crimes, Combs and members and associates of the enterprise pressured witnesses and victims, including through attempted bribery, to stay silent and not report what they experienced or knew to law enforcement. On phone calls, Combs and other members and associates of the enterprise, among other things, provided these victims and witnesses with a false narrative of events in an effort to conceal Combs' crimes. Combs caused these calls to be recorded on at least 2 occasions. That's probably going to be one of the reasons why, if the judge keeps him in custody, not for having the defaced firearms, because I don't think there's anything that prohibits him from having firearms, but defaced firearms are in fact illegal. But the fact that he's been allegedly tampering with witnesses, that is a big reason to keep Mr. Combs in custody. Next, the racketeering activity. From at least 2008 through the date of this filing, the indictment in Southern District of New York, Sean Combs, by persons employed by and associated with Combs Enterprise, in paragraph 6 and 12 of the indictment, engaged in these activities of which affected interstate and foreign commerce, knowingly combined, conspired, confederated, and agreed together with each other to violate the racketeering laws of the United States, to wit, 18 United States Code 1962, that is, to conduct and participate directly and indirectly in the conduct of the affairs of the Combs enterprise through a pattern of racketeering activity, as the term is defined in 18 United States Code 1961-1 and 1961-5, consisting of multiple acts involving kidnapping, chargeable under the following provisions of state law: California Penal Code, and they cite those. I'm not going to go through all those. Multiple acts involving arson, chargeable under the following provisions of state law: aiding and abetting and conspiracy, multiple acts involving bribery, chargeable under the following provisions of state law: California Penal Code, conspiracy, multiple acts involving Title 18 United States Code 1512 related to tampering with witnesses, victims, or an informant, multiple acts indictable under 18 United States Code 1589 and 2 relating to forced labor, multiple acts indictable under 18 United States Code 1591 and 2 relating to sex trafficking, multiple acts indictable under Title 18 United States Code Section 2421, 2422, and 2 relating to the transportation and inducement to travel for purposes of prostitution and other illegal activities. Multiple offenses involving the possession of intent to distribute, distribution of narcotics, controlled substances including codone, oxycodone, alpha-lazepam, and I'm going to not go through all of them because we'll mispronounce them. And as part of the conspiracies, the defendant agreed that a conspirator would commit at least 2 of these acts, because that's what they have to show under the racketeering activity. You have the count of racketeering activity, then you have to show the predicate acts. You get 2 or more of those, it's a RICO, and then the sentencing comes in. The government also gives notice of special sentencing factors in that affecting interstate and foreign commerce. Mr. Combs knowingly recruit, enticed, harbored, transported, provided, obtained, advertised, maintained, patronized, and solicit by any means a person knowing and in a reckless disregard of the fact that means of force, threat, or force, fraud, and coercion, and any combination of such means would be used to cause the person to engage in commercial sex acts in violation of the law. Then we got 2 counts. Count 2, sex trafficking by force and coercion. Count 3, transportation to engage in prostitution. And then we have the forfeiture allegation, which is basically saying, hey, we want to take all your property there, Mr. P. Diddy, Mr. Sean Combs, and guess what? Better save that $48 million mansion, because the government's going to say, we're going to get it because it was obtained through illegal means. Now, I know that was a lot, ladies and gentlemen, but I think it's important to be able to go exactly to it and not paraphrase and summarize like they do so oftentimes on the evening news, and you get just a little snippet. There you have it. Doesn't look good. I would predict, I could be wrong, I would predict that Mr. Combs remains in custody. Not because they can't make arrangements to make sure that he is around and they can find him, but the fact that they're concerned that he is going to tamper with witnesses. That's where the issue becomes. Next, Ashley Benfield. Remember her? She's the woman of been convicted of killing her then ex-husband, and her attorneys filed a couple of motions, and I said, well, I think there's one issue. Well, guess what? The judge agreed with me. And that issue is that the judge presiding over her hearing for a motion and to determine that he would bring in the jury panel to be interviewed based upon the defense allegations. Now, Ms. Benfield was not there, but the attorneys were, and this is what's going to happen. So first, the judge is going to talk to Juror 15, who deliberated in the case and is accused of lying on her questionnaire given to the prospective jurors before voir dire. Now, the document lets everybody know that the form is filled out under the pains and penalty of perjury, so be truthful. Anyway, the juror apparently denied having any experience with domestic violence, courts, or heated custody battles. But guess what? Ms. Benfield's attorneys found that that same person was served an injunction during their custody dispute and was listed as a victim in multiple domestic violence cases. That seems to be a little contradictory to what was on the form and what was signed. Even the judge agreed. Anyway, the prosecutor argues, hey, there's no evidence of any internal. Prosecutors argued that there was, no evidence of intentional deception, and accused the defense of failing to ask the appropriate questions during voir dire, saying, hey, you just can't rely upon those questionnaires. No, Miss Assistant State Attorney Suzanne O'Donnell, one of the reasons why you do the questionnaire is so you have limited time, and you are supposed to be able to take those answers to the questions on the questionnaire, which are subject to the pains and penalties of perjury, as true, so you don't have to rehash all that in open voir dire, hence saving time. Anyway, the judge is going to inquire of that juror 15. The other issue is that there's an allegation that a juror snuck a phone into the deliberation room and was texting out updates. Now, once again, the DAs argued that the comments on a live stream are insufficient evidence to prove that a phone was actually in the room. And even if the phone was in the room, there's insufficient evidence to suggest that any messages were in fact sent out to this particular information, or that information was coming in. Well, the judge says, we're going to bring them all in, and I'm going to question them in camera, which means back in chambers, to find out what actually took place. Now, guess what? The jurors are going to be questioned separately, so they're not going to all be in there, and they can talk about what others are going to say. Now, the defense and the prosecution will have to submit questions that the judge will ask, and guess what? The judge has already offered Juror 15 a court-appointed attorney. Why? Well, because it appears quite obvious that this juror may have some Fifth Amendment rights against self-incrimination if she doesn't have a very good answer or explanation. She just happened to forget that protection order and all those domestic violence cases that she happened to be in. Oops, just forgot through the entire proceeding. I hate to say it, ladies and gentlemen, but this is becoming a little too often, happening just a little too frequently, where these jurors, I think, are thinking they're going to get their 15 minutes of fame, write a book, who knows exactly. They're for a particular side, but the reality of it is, if there's juror misconduct, give Ms. Benfield a new trial. And particularly if somebody had a cell phone in the jury room, give her a new trial. Like I said, we'll have to see. Now, obviously, Ms. Benfield's attorneys are expected to file new rounds of motion, depending on what is learned with the questioning of the jurors. We'll keep you posted, ladies and gentlemen. It's never easy, is it? If everyone would just follow the rules, it would be a heck of a lot easier, wouldn't it? Next on the docket, remember the Donna Adelson trial, the one that we were going to bring you live? Well, it's been paused before it even got started. So it turns out the trial was delayed after her lead defense attorney withdrew this afternoon due to concerns about a conflict of interest. Now, let's go through this, ladies and gentlemen. I don't think you need to be a lawyer to figure out that there was a conflict here. Why this only came about now is beyond me. Anyway, like I said, Donna Adelson had the same defense attorney at trial as her son, Charlie Adelson. That's right. The attorney was Daniel Rashbaum. Why would he be representing mom when he was representing the son, who is a witness? That's right. The son was listed as a witness against the mother. That's not a problem. That happens all the time. But when the attorney is representing the defendant, but also represented the witness, you've got a conflict. Why Mr. Rashbaum stayed on this case is beyond me. Why was this only brought up recently? Like I said, the jury selection was supposed to begin today, but it was paused. They brought in over 100 potential jurors to the courthouse, but the judge called a recess because they had to resolve this issue of a potential conflict of interest. Why nobody brought this up, I don't know. But Charlie Adelson's appellate attorney filed a notice Monday with the court saying that he is invoking his client's Sixth Amendment right to keep his previous attorney-client communications with Mr. Rashbaum, his attorney, and his mom attorney private. And he's not going to waive that because his case is still being appealed. Now, the appellate attorney, a guy by the name of Michael Ufferman, and Laura Cornell Niles argued that Rashbaum should not be able to cross-examine Charlie Adelson, nor should his co-counsel, Alex Morris. I agree. Mr. Adelson would assert that his privilege and the conflict of interest applies to the entire defense team in Mrs. Adelson's case, and Mr. Adelson should not be subjected to cross-examination by any member of the defense team who has been tainted by Mr. Rashbaum's knowledge and information. I agree. Anyway, Morris argued Tuesday morning that because he was not involved in Charlie Adelson's trial, he should be able to cross-examine him. I don't agree. The judge called a recess to allow Donna Adelson to consult with an independent attorney, and when she returned at approximately 10:30, the judge questioned her directly. Ms. Adelson said after consulting with defense attorney, she wanted to retain Rashbaum as her attorney and waives any conflict of interest. The problem is the conflict is with the previous witness. He has to waive the conflict. And if he can't, you can't go forward. So ultimately, Mr. Rashbaum has decided to withdraw, even though apparently nobody saw this as a potential issue at all. I'm not sure why Mr. Rashbaum didn't get a waiver if he thought he was going to stay on to get both people independent counsel. But then when the other son gets independent counsel, his appellate attorney, he's like, I'm not waiving anything. No. Now, this could be all a big tactical decision to delay the trial, but the reality of it is this issue should have been resolved early and often. The prosecutor should have brought it up. Heck, the defense attorney should have brought it up. This is a no-brainer. You can't represent a defendant when you previously represented a witness that's going to be called to testify. Why would you even go there? I don't care how many hoops you jump through. I had a case where we represented a defendant, another witness gets charged. I said, it's possible, but everybody's got to get an independent counsel, and everybody wanted to rush do it. I said, I'm not doing it unless everybody has independent counsel. Somebody else jumped on and let them deal with the ethical conflict way down the road. Simply not worth it. Next, we have a case of, is it self-defense or murder? And we all know if you murder somebody in self-defense, it's justifiable homicide. But if it wasn't self-defense, then it's just good old-fashioned homicide. Well, please meet Bradley Turner. She allegedly beat a guy by the name of Michael Hodge with a bat and then stabbed him repeatedly with a tire plug tool back in August of this year. Now, the violence occurred in an apartment in Bloomington, Indiana, where police found Mr. Turner covered in blood and lying on a couch. Now, the defendant initially claimed self-defense, saying to the police, I had to defend myself, dude. Police didn't buy that story, saying instead that the evidence at the time pointed to attempted murder. But guess what? Mr. Hodge died on September 11th. Now those charges have been converted to murder. Now, of course, the defense can always say, hey, there was intervening causes. He got sick. He got an infection. Who knows what the causes were? But you can say the medical personnel killed him. Not me. He was fine. It's murder. She's going to trial on murder charges. So what we do know is, according to the Bloomington, Indiana Police Department, when they arrived, there was loud music blaring at the apartment where Mr. Hodge was beaten in a bathroom with a baseball bat and stabbed multiple times. That's according to the probable cause affidavit. They found a bloody kitchen knife, a black-handled tire plug tool with a metal spike on it, and a baseball bat in the living room. Now, the bathroom and the kitchen with the bat left leaning against the wall. Now, during the police officer's initial observation of the bathroom, it was determined that there was a bloody plastic handle to a kitchen knife with the metal knife portion missing near the bathtub. There was also a bloody black-handled tire plug tool and a metal spike on it located on the floor near the sink. And in the living room of the apartment, on the main floor, there was a bloody baseball bat against the wall. Now, Mr. Hodge had told police that Ms. Turner attacked him unprovoked when the two were, getting ready to take a shower together. And after being struck with the baseball bat, the victim stated that Miss Briley began stabbing him all over his body. He stated that he tried to grab the knife as Briley was stabbing him in an attempt to stop the incident, but was only sustained a cut to his hand. He stated that there was no argument or reason for the attack. It was completely unprovoked. Now, Turner, for her part, allegedly had a completely different version of events. She says that Mr. Hodge tried to put stuff down her throat and that she had no choice but to defend herself. They did note that Miss Turner had numerous bruises covering her legs and her sides, but they concluded that those bruises appeared to be older due to the multiple colors of purple and yellow, and no new injuries appeared to be observed from the day of the attack. Now, aging of bruises, ladies and gentlemen, not exactly an exact science. Some could even say it is a faux science, so to speak. Yes, but it all depends on the person. Anyway, don't think that's the strongest piece of evidence for the prosecution. Anyway, Turner was described as acting erratic at the time, including hyperventilating and repeatedly making jerking motions with her extremities and loud moaning and whimpering noises when investigators tried to ask her questions. Turner had allegedly claimed that Hodge tried to get her. She said, quote, "He effing tried. He effing held me down, and he tried to put that stuff down my throat," she alleged. "I don't know what he put in my throat, and I had to defend myself, dude. I tried to defend myself." Now, Turner is facing the pending burglary of a dwelling case that stems from an August 6th incident that she faced several drug possession cases in recent years, including possession of methamphetamine. Now, prosecutors originally charged Turner with aggravated battery and attempted murder. Obviously, they've been upgraded. She is scheduled for a court appearance on October 7th, and trial is scheduled to begin on February 10th of 2025. Always interesting, ladies and gentlemen. Always interesting. Self-defense or murder. Next on the docket, this day in legal history, a big day on September 17th, 1787. The 39 delegates to the Federal Constitutional Convention in Philadelphia adopted the United States Constitution. There you go, ladies and gentlemen. The Constitution matters, does it not? Yes, it does. And finally, our dumb criminal of the day. Now, a suspect is still at large after assaulting a customer at a Panera Bread here in Denver, Colorado, specifically in Glendale, Colorado. Now, police say the suspect, identified as Isaac Ross, also known as Kendall Ross, came into a Panera Bread and caused a bit of a disturbance by screaming and hitting things and throwing items off the counter. The suspect was yelling at the workers, and they were a little confused as to what was going on. And one of the workers says, "Hey, I don't have your phone." Anyway, when Ross threw something at the employees, which police later said was a smoothie, there's a video of customers trying to tell Ross to stop. Ross yelled some racial slurs at one before continuing with the disturbance. Then Ross knocked everything off the counter, and one customer jumped in to try and get Ross to stop. Well, the next guy actually kind of saved that guy from getting attacked further, according to witnesses, because they held him down. And then the video shows an employee coming out from behind the counter, getting involved with beating Mr. Ross with a pan. Eventually, Mr. Ross gets away before the police arrive. But guess what? Mr. Ross returned to the business, continuing to cause a disturbance yet again. Now, during the second altercation, Ross assaulted an at-risk male who received minor injuries as well. Needless to say, they are still actively looking for Mr. or Miss Ross. If anybody knows well about, contact the Glendale Police Department. All we know is Mr. Ross or Miss Ross, you are the dumb criminal of the day. Man, why can't people just go in, buy their food, and move along? Kudos to the Panera Bread employee that took matters into their own hands and protected themselves and those of others. There are a few more beatdowns, ladies and gentlemen. There'd be a lot less crime. Just saying. Not condoning violence, but you do have a right to defend yourself. Always consult with your local attorney as to applicable local laws. All right, that's all we have for you today, ladies and gentlemen. Thanks for joining us. I know it's kind of a long show, but I thought it was important to bring you the actual indictment in the Sean Combs case. Please join us tonight, 6 p.m. Mountain Time. We'll see you then. Remember, the Constitution matters.